the Second Circuit, Reid v. Garland. It's about mental competency. And, it used to be all the rage when I was an attorney advisor in immigration court. It was like towards the end of the Obama administration, and they were just putting these things, matter of MAM, matter of mom, had just been issued recently, and what safeguards are due in immigration court. By the way, survived Trump 1. I expect it'll survive Trump 2. That is, giving attorneys in removal proceedings to those deemed mentally incompetent and requiring these safeguards. And in this case, the immigration judge essentially messed up, said the Second Circuit, because everybody recognized that Mr. Reid was not competent to represent himself. He was deemed incompetent. He was, schizophrenia and all the serious things. And there was a finding that he was not even competent to assist his attorneys. But essentially, the immigration judge did what immigration judges often do, and they say a bunch of stuff, and they say, well, Mr. Reid has the ultimate safeguard, an attorney. And they were good attorneys, it would appear. But, if you can't work with your attorneys, how good of a safeguard is just having an attorney? That's paraphrasing the Second Circuit. But also, what the Second Circuit said is the IJ needs to make specific factual findings as to the degree and scope and character of the mental incompetency, and then explain what safeguards were implemented to account for all of those incompetency issues. If they don't do that, says the second, it would appear, they're not eligible to ascertain whether appropriate safeguards were implemented, right? Because you got to first say what all the problems are, and then say how you're accommodating all of those. In this case, for example, they were saying, well, maybe you could have ordered a social worker, had a social worker get in to help him for many months, help him remember certain facts, because this was actually about former Section 212C relief, and his remembering and working with his attorneys actually was very important for his substantive eligibility for that relief, and he was not able to do that. Quote, to order the removal of someone unable to participate meaningfully in his or her removal proceedings without adequate safeguards would make the whole process a charade, end quote. So, big deal stuff. Also, another quote, for termination generally, which again might be important for Trump round 2 for us immigration attorneys, not just for mental incompetency. There are a bunch of regulations, and a lot of the regulations that are there are for EOIR are designed to protect constitutional rights, like due process rights. And quote, whereas here, respondent claims that an agency failed to adhere to their own regulations regarding a fundamental right derived from the Constitution or a federal statute. In a deportation hearing, he is not required to make a showing of prejudice before he is entitled to relief, end quote. That's a big deal. Quote, for us who practice in removal proceedings, it's not necessarily the law in every circuit as I understand it, but, that's how they try to get you when you're trying to terminate. They're saying, well, okay, there was a violation by ICE or the immigration judge. I'm not saying, that they were doing it intentionally, but it did happen. But it didn't prejudice your client because it would have been the same result anyway. You know what I mean?
Yeah.
Like that kind of rationale. And when the regulatory violation is designed to protect these fundamental rights, or even another federal statute, or right derived from federal statute, no prejudice is required. I mean, that's just flat out, you're entitled to relief, which is often,